To give the team in the commercial division strength and wisdom to handle the workload that they did in this season. Lord, now as we gather here to evaluate, to reflect, and to hear the lessons that we have learned in this season, we want to say thank you. We thank you that reconciliation is in your heart. In 2 Corinthians 2:15, you say that you've given us the ministry of reconciliation. We know that in this you bring to get people together in unity. Lord, as we sit here together, we want to say thank you. Bless this program as it runs throughout this morning. In Jesus' name I pray. Amen.
Thank you so much. Take our seats. My Lord, Honorable Principal Judge, my Lord, Chairman Council of the Judicial Training Institute, my Lord, the judges of the High Court present, Governor Bank of Uganda, Chief Registrar, the CEO, Uganda Bankers Association, the Chief Executive Officers, the bank's president, your worships, members of senior management present, and all invited guests. You are most welcome this morning to this very important breakfast meeting. My Lord, Principal Judge, we have a very brief program that I beg today. We shall have welcome remarks by the Director, Judicial Training Institute, Honorable Justice Professor Andrew Oga. We shall then invite you to assume the chair of this session and proceed to make your remarks and lead us into the status report of the mediation settlement fortnight by the 8th High Court Commercial Division. Equally, take us through the plenary discussion, and thereafter we shall have remarks Bank of Uganda to be proceeded with an awards recognition by the chairperson, Performance Management and Awards Committee, who is also the chairperson, Governing Council. We shall then proceed with your remarks, and we shall be closing with the anthems and a group photo and departure. With that, my Lord, allow me to invite the Honorable Director, Judicial Training Institute, to welcome and make some recognitions of the VIPs we have in the room that will steer us into the next phase. My Lord, welcome.
Thank you, Public Relations Officer, Judiciary, my brother, Your Worship James Eremia. My Lord, the Honorable, the Principal Judge, allow me to stand on the protocol laid by the Public Relations Officer. And my Lord, I want to today request that you permit me focus by and large the welcome remarks on appreciating the people that have been key in the milestones that the commercial court has been able to achieve at the settlement fortnight. And my Lord PJ, I'll begin by appreciating the Honorable the Chief Justice, the Deputy Chief Justice, yourself as head of the High Court, the Chief Registrar as the head of the registries in the judiciary, and the Permanent Secretary who has always financed these activities. I think, Chair, if you don't mind, you would begin by clapping for them. My Lord PJ, we are encouraged by the leadership of the CJ and members of the Judiciary Top Management. The efforts that you have put in ring-nearing ADR, I think are the reason you see ADR taking shape in the country. I say this because just a few days ago, you were on phone coordinating the mediation efforts of settling the cultural dispute in Bugis. You didn't leave it to us as the panel of mediators, but you kept engaging the parties to see to it that we closed the case. Ideally, you would have sat in your comfort zone and left everything to the panel. The CJ also was equally guiding us, following up on how we are progressing, and the same has been done in the settlement fortnights. You went to the commercial court and gave the commercial court support when they were flagging off their fortnight. You've done the same for the land division, done the same for the family division. So that leadership is what has helped us achieve. My Lord PJ, I want in a special way to thank the Governor Bank of Uganda. The governor has mobilized chief executives. From the time we began this activity, but you also recall Bank of Uganda partnered with the judiciary to organize a round table that we had in Serena Chigo. And some of the recommendations were, can we focus on clustering the disputes? And immediately after that event, we went into this fortnight. I always say, and I beg that the judges do not harass me for what I'm going to say. Judges are very difficult people. But I want to tell you, PJ, the commercial court is a very interesting breed to work with. You call the head of the division with her soft-spoken voice, and she's available to mobilize the judges within short notice. There are no excuse of we needed a 1 week, a 2 weeks, a 1 month notice. So this has made it very, very, very easy for us to work with the commercial court. The CR in particular, the organization within the registries is something that we really want to appreciate you for the leadership of the registries. The ADR registry, the JTI registry, these are registries that have supported this activity, and we really appreciate you. Chair Governing Council, I don't know what to say, my Lord PJ, but the humility, the calmness with which the Chair Governing Council offers leadership to us at the JTI. He speaks in a soft way, but there's a lot of work that we achieve and realize. We enjoy working with him. This morning at 5 a.m., he sent me a message just to greet me. And I replied, and then he said, We'll see you soon. So when I reached here, I sent him a message that I'm here. He said, you have beat me at it today. I thought I would be there before you. So, Chair, we really appreciate you. We sincerely appreciate you. My Lord PJ, I now invite you to chair the session. Thank you.
Thank you so much. A very good morning. When I was coming in here, I was feeling so rich and I was wondering, why am I feeling so rich this morning? Then when I came here, the first person I saw was Governor Bank of Uganda and everyone. So really, really happy to host you this morning. And we're a little bit running late, but we shall salvage this time because we really want you to be out of here by 9. So I am the one chairing this morning. Greetings from the Honorable the Chief Justice. Greetings from the Honorable the Deputy Chief Justice. They really wanted to be here this morning, just because of what happened in the commercial division in the settlement fortnight. But unfortunately, they were not able to be here, but they sent their greetings. And they said I should come and represent them. And I was so excited because that's what I wanted. I wanted to sit in the middle here like this. Yes. So we have a very short program this morning. We are going to, but first of all, I want to thank the commercial division in leading us through this and showing us that it is not about just litigation, that we can actually achieve this. And we want to stop, maybe with time, stop this settlement fortnight and make it a case management tool. It becomes the usual business. You know, we don't want it to be business as usual. Unusual. We want it to be business as usual. So thank you so much, Commercial Division, and of course the chief executives mobilized by the governor himself. Your presence here today just gives them all the confidence that this is the way to go. So thank you so much for mobilizing them and being here. This morning we are going to get the status report of the mediation settlement fortnight by the head of division. My Lord, you have 20 minutes or less to give us the report so that we can now, 20 minutes, we shall be making comments on it. My Lord, Honorable Justice Anna Mugenyi, please take the floor.
Thank you, my Lord PJ. Good morning, my lords and everybody present this morning. Good morning, Chair Governing Council. I will stand on the protocol that has already been laid and quickly take you through the status report. Thank you. The commercial division successfully conducted the mediation fortnight as part of its commitment to promoting ADR and expediting the resolution of commercial disputes. During the exercise, 527 mediation causes were cause listed. This is the fortnight of the last 2 weeks of May and the mediation session that continued 60 days after that fortnight. And the information I'm going to give you is as at 16th July 2026. During the exercise, 527 mediation causes were caused to maximize case disposal and provide parties with additional opportunities to settle disputes. Mediation continued within the 60 days rule beyond the official mediation fortnight. By the close of the mediation period, 417 mediation causes were completed, achieving a 79.73% completion rate. Of these 97 matters, Of these, 97 matters were successfully settled through mediation, amicable resolution of disputes with a combined subject matter value of Uganda shillings 90 billion 679 060,954 shillings. These settlements enabled parties to avoid prolonged litigation, reduced legal costs, preserved commercial relationships, and facilitated faster realization of business outcomes. That table just shows you the number, the 527, the completed 417, the completion rate, the successfully settled matters 97, and the subject matter value that was settled. As I told you, the mediation fortnight was held from 18th to 29th May 2026, and it focused on the expediting resolution of banking, loans, and credit-related disputes. The objectives are well known: fast-tracking banking, loans, and credit disputes, promote ADR, reduce commercial case backlog, improve access to justice, reduce litigation costs, and enhance timely disposal of commercial cases. These tables just show you that we had a total of 23 judicial officers, registrars, and accredited mediators who participated in the fortnight. It shows the number of cases completed before the mediators. The first table shows the judicial officers who are also mediators, and we handled that number of cases. This upper table shows the registrars who handled mediation, and the third table shows the non-judicial officers who participated. So when you add all those figures, you get the 417 that was concluded. This table shows the unsuccessful cases, 114, the fully settled were 92, and the partially settled were 5, and those that failed were 127. The pie chart shows you that information. As earlier said, fully settled were 92, partially settled were 97. The key observation here is that the mediation fortnight was a highly successful ADR. What is very important for us and which we're very proud of is that we were able to unlock disputes worth 90 billion shillings, which demonstrated a significant contribution to the timely and cost-effective resolution of commercial disputes. Now, we thought we would bring this information to you to show the value and the effect of ADR. One of the highest value cases that was successfully resolved through mediation during this period is that mediation cause 0697 of 2026 between Bank of India and Qualicof Uganda Limited. The dispute involved a subject matter of about 5.29 billion shillings. It was filed on the 24th of April 2026 and was fully settled through mediation and closed on 25th June 2026, taking 82 days from filing to completion. The successful resolution of this high-value commercial dispute demonstrates the effectiveness of mediation in facilitating timely, cost-effective settlements while preserving business relationships and reducing the burden. The youngest case which was successfully settled is mediation code 0765 of 2026 involving Absa Bank and Joe Doe. That's a pseudonym. We didn't want to mention the person. The subject matter was 56 million. It was filed on 29th April 2026 and fully settled through mediation, leading to its closure on the 29th of May That's completed within 30 days. The dispute was resolved within a relatively short period, demonstrating effectiveness of mediation in achieving expeditious settlement of commercial disputes. Now, there's another case that we really think we should share with you to show the impact and effect of mediation. This is mediation cause 658 of 2026, Joe Doe, that's a pseudonym, and another versus Absa Bank. This is a 2020 case, critical backlog. It was a critical backlog case, and there are many others like this, but we thought we'd bring out this one. It was filed in 2020. Mediation started on the 23rd of April 2026, and it was concluded fully settled on the 25th of June 2026. You can see it's a 6-year-old backlog matter originating from 2020 and resolved through mediation in 2026. This case, the subject matter was $2,164,209. It was settled within 89 days, having been in the system for 6 years. This really demonstrates to us the effectiveness of mediation in unlocking and resolving long pending cases. I think this mediator deserves a clap. And there are so many like this, but we are very excited at the commercial courts about all this that has happened during the fortnight and the 60 days that followed. So the key achievements, as I've already said, for 417 matters were concluded, 97 were fully settled. There was a significant reduction in pending mediation files, increased awareness and utilization of court-annexed mediation. It enhanced collaboration between judges, registrars, mediators, advocates, and the Bankers Association, and we were able to unlock that 90 billion into the economy. The challenges are the usual ones, but we know we shall overcome them. Non-attendance of parties and advocates, which kind of delayed the mediations. Then there were some complex commercial and banking disputes which required more time, and we agreed as that even though the 60-day rule applies, if there's some kind of potential towards a successful mediation, would extend the period a little more. That's why you see 89 days, 82 days. But at the end of it all, there was a successful negotiation. Then we also faced representatives who didn't have authority. They would come for the mediations and they would keep going back and forth, which kind of delayed the negotiations. The slow decision making, again, because of the officers who didn't have authority. Delayed approvals from bank headquarters. I think all this is related to the officers who didn't have authority to carry out the negotiations. But there are some who were given the authority and were able to proceed with the mediations in the shortest time possible. There were also some advocates who were kind of resistant, but we brought them on board, although it delayed the mediations. The recommendations continue, sector-specific mediation drives for different clusters. We intend to have these mediation fortnights every quarter for different clusters. And the next cluster will be the trade and construction cluster. Increase awareness among the public, conduct monthly mediation review meetings, continue with early referral to mediation for deserving cases. We require the lawyers to file their pleadings with mediation causes so that we can cast the net wider and be able to bring more cases in for mediation. We would require banks to send representatives with full settlement authority, establish dedicated bank mediation officers for faster decision making, encourage early referral of disputes to mediation, promote cooperation by advocates, and discourage unnecessary procedural delays, and then also to strengthen oversight and transparency in foreclosure processes. The mediation fortnight and the subsequent 60 days significantly enhance the resolution of banking, loan, and credit disputes within the commercial division. We appreciate the judges, the mediators who participated in the mediation fortnight. We would like to thank the Chief Justice, the Deputy Chief Justice, the Principal Judge, the Focal Judge ADR, Justice Kauka, and all the litigants, the bankers, executives, and all those who made this fortnight successful. Thank you so much for listening to me.
Thank you so much, my Lord Justice Anne Mugenyi, for giving us everything in that fortnight. And as we can see, not just about the over 90 billion that was unlocked, but mediation, unlike litigation, transforms conflict into an opportunity for reconciliation, healing, and of course, sustainable peace. A judgment, there's a winner, there's a loser. But mediation, people go healed because it is, and even whatever they agree to, they can actually implement it because it was born from that discussion. So thank you so much, my Lord Anne. And I will now give about maybe 3 interventions. If there's any question, if there is anything that you'd want us to share, because today is a day for us to step back and see what worked during the settlement, what didn't work, what should we drop so that the next settlement we do better. So I will now give a chance to anyone, any intervention, whether it's a comment, whether it's a question, whether it's a clarification.
My Lord PJ,
Yes, please.
maybe at this point, I would also request that some of the commercial court judges also share their observations, just 5 minutes, or experiences.
Okay, it is your day, really. What can I say?
Thank you, my Lord, Honorable PJ. Allow me to adopt a protocol that was already laid. And at this time, I would like to add my voice to thank you for the leadership and the top entire management. Or observation relates to the backlog. As at 30th June this year, we had a backlog of about 1,798 cases. And when we look at the number of cases that were completed by the judicial officers, of about over 200 cases within a period of 60 days. This is amazing, where a total number of 97 cases were concluded. Now, when you look at the protracted litigation process, the lead time for completion of a case is about 2 years and above. The importance of ADR cannot be underestimated. And having locked 90 billion shillings for the economy, this is commendable, and it sustains the economic development of the country and promotes growth and development of the economy. Thank you so much, my Lord.
Thank you, my Lord Susan. I thought you were going to say that having unlocked over 90 billion, now finance should increase the budget of the judiciary. But it didn't come to that. Thank you so much, my Lord. Susan, is there any other judge for questions?
Thank you so much, my Lord, the Honorable PJ. I'd also like to add my voice to thanking the Honorable Chief Justice, the Deputy CJ, the Honorable ED, JTI, the entire top management for the support that you gave us as we started this particular session. We would not have gone this far without your support. I wanted to just make a brief remark on how relationships are restored under ADR. Particularly from the banking sector, we had cases where when the parties come in, they do not even want to speak. So they want the lawyers to be the ones to take the lead. So you can even just feel it as a mediator that even the moment they walk in, this is a situation that has broken down completely. But through the mediation, by the time you get to the second session, then you see them opening up, and as a mediator, then you use your skills to see how you can then encourage them. So through that, through the sessions, then you realize that there are misunderstandings because they were not given an opportunity to be able to air them out in a free space. Then they begin to speak up, and then you realize that even where the misunderstanding was, after through the discussions and each party opening up, is that they then each begin to understand where the relationship actually broke down. By the end of the session, my Lord PJ, is that you even have them shaking hands and even wanting to sit next to each other and saying, "Oh, we now understand where we both went wrong." And for as a mediator, that gives you a lot of satisfaction because you know that is a dispute which has been brought to finality compared to litigation where you have a judgment and then there's an appeal. You have no idea how that is going to be resolved. So we are really glad that this mediation is helping the parties to be able to resolve the disputes, but it also enables them to pick up their lives and then go back. I had one interesting one where the lawyer allowed the litigator to speak and he said, I had hated this bank from this, but from here, after this signing of the consent, I am going to go back for another loan. That was amazing. Thank you so much.
Thank you so much, my Lord Patience. I think that's the truth. Conflicts really bring people's lives to a grinding halt. So after mediation, people can leave now. Thank you so much. Yes, my Lord Gina Mia Melody.
Thank you, my Lord PJ. I would like to start by associating myself with the comments made by my colleagues at the Commercial Division. And with that, I would like to make two comments. Firstly, I would like to say that this time round, the air was different. And this is because we had all the CEOs from the banking sector on board. So that was really helpful. There was that general excitement in the air about the entire mediation process. I, however, wish note that there was a small gap in that in some few instances, it's as if the in-house counsel in some of these banking institutions were not fully on board. There are those who came to mediate and have the matter settled for the get-go, while there were a few others who came with um, a negative stance right from the onset. Some were able to cajole into the settlement mood. Others just did not come on board. I can't mention the institutions, but I have to say that for those few that did not come on board, it ended up frustrating the settlement of those matters. I think in future, it would, much as we have the CEOs on board, it would be good to have the in-house counsel on board as well, because they are our link to the bank during the mediation process. For instance, some of the matters that we were handling just required reconciliation, bank reconciliations. And these were the people who are supposed to help us to get that. But where someone is not willing to take that step or does not show up for subsequent meetings, it makes the whole process difficult to ensure its successful completion. So my request is that next time, maybe through the CEOs, we can bring on board their in-house counsel to understand what the assignment is about and how it's all about a win-win for both the banking sector and also for the borrowers. My second and final comment is something I observed about inflated loan amounts. It came up in one of the matters that I handled, where the plaintiff clearly admitted that she borrowed money, but that was not the amount that she borrowed. And that credit institution was very quick to pull out documents that she had apparently signed. But from the handwritings, I could tell that it was filled in by an officer of the credit institution. Luckily, she had bank deposit slips indicating the amount that she was actually given. And for me, that alone confirmed that the amount that she was being required to pay had been inflated by about 60 million, which she didn't even have. So my question at this point is, how can we protect such borrowers? I know it's slightly outside mediation, but I believe it wouldn't have come up if I was not mediating such a matter. I think there needs to be a deliberate step towards protecting such members of the public, because these are ordinary people, and this is a lady who was about to lose her home because she had given it as a collateral for the loan that she was to receive. But she just didn't have the extra 60 million that she was being required to pay. Thank you.
Thank you so much, my Lord Melody. I think the chief executives have taken note. Please bring the in-house councils on board. That would be helpful to us. I'll come to you. I'll come to you definitely. Let me just finish up with, yes, my Lord Patricia. I just finish up with their lordships and then I can come back.
Thank you, my Lord PJ. Just wanted to emphasize the issue of backlog. When we handle civil suits, most of them, there's usually at least one or more applications, and this wastes actually more time. And because of these applications, this increases the number of cases that we handle as a commercial division. But when a matter is settled through mediation, that is the end of it. So we don't have many more applications. And so, really, just to emphasize the importance of mediation in reducing backlog and therefore returning money to the economy. I also wanted to point out the issue of costs. When you handle a matter through mediation, especially at the beginning of the suit, then you reduce costs and, for example, legal fees that the different parties would be incurring as a result of a civil suit. And then I've also noticed the issue of the emotional toll that a case takes on the parties, especially when they're individuals. Maybe if it's a company, not so much. But for individuals in banking cases, sometimes you find a witness come and then they break down. So it takes really a toll on them. So mediation really is the way to go. And I'm really praying and hoping that as seeing the results that we have today, that will really go the way of mediation. As PJ has said, that this will be actually the norm as opposed to fortnights and the promotions that we are having. Thank you, my Lord.
Thank you so much, my Lord Patricia. I like the commercial division. Ladies first. Then the boy child comes. The only boy child in the commercial division. Yes, my Lord Thomas.
Thank you, my Lord PJ. I'll adopt the protocol that has been laid down. I just have a few remarks to make. First and foremost, I would like to send appreciation to the Governor Bank of Uganda for really mobilizing the CEOs to be part of this process of the mediation. One of the things that we'd like to take away from this mediation fortnight is when you look at the matters that are resolved, these matters, for all intents and purposes, are concluded. There is no matter from mediation that is going to the Court of Appeal in the form of an additional appeal going forward. So I think we deserve a hand clap for that aspect, because certainly the Court of Appeal is now being cushioned by this mediation at the High Court. We are not having appeals going to be going up forward to to the Court of Appeal. Just a clarification on the issue of banks additional authority. I'd like the CEOs to really be mindful, especially those who have the international headquarters outside. Let the international headquarters know that this is a process that is now ongoing in Uganda, and there are many benefits that can be achieved by it. So the speed turnaround for these results or the decisions that need to be made should be improved, especially we have to go to the international headquarters. Mediation is not a failed mediation or an unsuccessful mediation doesn't mean that the parties cannot talk. Once the mediation is failed, the time has lapsed, we send the matter back to litigation, but the parties still have an opportunity of reaching a resolution before the trial judge. Try and do it. There are matters that may have gone through mediation, have not been successful, but don't shut your minds to the aspects of mediating or reaching a resolution of the dispute even before the trial judge. Let's keep an open mind even while litigating, that we can have this matter resolved through a settlement that can be concluded before the trial judge. Then, as we are now going to the another fortnight. This is the trade fortnight, which is on the 17th to the 28th of August. I would implore that the CEOs and the banking sector who've taken benefit of this mediation fortnight, you now be ambassadors of mediation to the traders who are going to be coming to us during this fortnight. We have about 1,149 trade cases, of which 603 are backlog. The total amount is 931 billion 636 million 630,000, around that. And we are hoping that we're going to use this coming fortnight to replicate what we had in the banking sector fortnight. So thank you very much, and that is what I would like to share with you during this process. And I really do want to thank the CEOs who followed through, who are with us today, and I hope you can appreciate the benefits that come out of mediation. Thank you very much, my lord.
Thank you so much, my Lord Thomas. Uh, Definitely, you're spot on. Mindset change is very, very key, and also calling on it is now a movement. Mediation is the movement, and it is going to move. And that is just we have to be patient with some people because they've been thinking litigation is the only way. Now we have to say there is actually an alternative. We should really be the way to go. So thank you so much. I think we are done with commercial division. Thank you so much for your comments. Those were very. I have a hand up there. Uh, can can they give? I see. Okay, it's worship. Yes, I am long-sighted. Yes, of course. Please give him the mic. Give him the mic.
Uh, yes, let me stand up. Thank you very much, my Lord Principal Judge, my Lords, Your Worships, and all our CEOs and our guests this morning. My name is Godfrey Kawesa, Deputy Registrar, Alternative Dispute Resolution at the DIA Registry. My Lord, I am very glad and privileged to have been part of the registrar mediators during the settlement fortnight. Two observations. The first one is that, my Lord, I resolved about 10 disputes successfully, and I thank God for that. But the first observation is that there was a tendency to fail to honor mediation hearing notices. And after serving the parties, we even made phone calls, and the parties were reluctant to come to court to have their dispute settled. I don't know why that was. Then secondly, my Lord, on the part of the banks, there is a tendency for some banks to breach consumer protection guidelines issued by Bank of Uganda. And the parties are ignorant about the dispute resolution mechanism instituted by Bank of Uganda to solve commercial disputes between borrowers and financial institutions. There is need for Bank of Uganda to sensitize borrowers about this dispute resolution mechanism instituted by Bank of Uganda, my Lord, so that less disputes come to the courts. I beg to submit, my Lord. Thank you very much.
Thank you so much, Your Worship. I think that's a very valid point. I think we don't thrive in ignorance. Let's sensitize. I think also it is also maybe for us to look back and say, did we do enough sensitization to the people for them to come, for the parties to come for this fortnight? And Bank of Uganda will definitely whip the chief executives and make sure that the unsuspecting public sensitize on the small print that you give us. My ED is there, housing finance. Yeah, always you give me the small print. Sign here, sign here. Good to see you. Good to see you. Yes, I think we might have to. Do we have just one more? Just one more? Burning? Yes. Yes, please. And then I will invite the ED Bankers Association, my brother Wilbrod, to at least introduce to us the chief executives here. I might open an account in another bank.
Thank you so much. Your Lordships will stand on the protocol that has been observed by the previous speakers. My name is Eva Navadam, the acting head of legal, Finca Uganda. The managing director of Finca Uganda, Mr. James Onyeta, is also in attendance. I am really thankful and grateful for this, and I am honored and privileged. I had to speak. I have a very strong litigation background, so I really do appreciate mediation, and I am happy that I have attended this because for sure I have been an ambassador for mediation, but now I am even, I don't know, double ambassador, but it is very I don't know to listen to that story and the 90 billion, but also to preserve the business relationship, which is sometimes taken for granted, but it is a very good thing when at the end of a case, a customer is, I will come back and get another facility or whatever. What I wanted to talk about is I really hope this exercise can go down to the magistrates courts for two reasons. One, for Finca Uganda, we are mostly micro lenders, and I know there are many financial institutions like that. That's one. But two, the pecuniary jurisdiction of magistrates courts has also been enlarged to 200 million, meaning most of the financial institutions that did not have a lot of cases in the magistrates courts are now going to have to file or to appear before magistrates. So I hope this exercise can go down to the lower courts and that it is not limited to the fortnight. So thank you so much. I also realize that mediations are helping us with the customers who have been using courts as tools to delay or avoid payment, are pointing out technicalities and the foreclosure processes being taken to courts, yet they should not. Now, through mediation, such issues are brought on board, and the financial institution is saved a lot of money, but also a lot of time. It's saved. Then, lastly, I want to talk about there's an issue about in-house lawyers. I would like to believe it may not be the in-house lawyers, it's just that we are the face, that we are the ones who come to court, that they are not on board. It might actually be our other officers in financial institutions, and we are doing a lot to educate them about mediation and the importance of producing documents when they are asked for and information and coming to court to give evidence. Trust me, we are also ambassadors for this, and we are going to work hand in hand with the judiciary to ensure that mediation is achieved. Thank you so much.
Thank you so much, and I can really see the passion that you are. You know, you love litigation, but now you love mediation. That is great, and I am so happy to hear that. And the judiciary will support. That's the way to go, and it will go down to the very last court. In 10 years to come, we might not be having any cases litigated. It might be 2%. The way to go is going to be what? Alternative justice system, alternative dispute resolution. So thank you so much. I think at this point, I see our time is running fast. At this point, I'll invite the ED session to introduce to us the chief executives who are here this morning. I see everybody looking like a chief executive, except the judges. You see, my Lord Andrew was saying that judges are very difficult people. Judges, you know, they tell us that we are always in such environment. We look aloof, very unmysterious. But you can see that all of them spoke really. We are just, I think it's because of mediation. So mediation is the way to go. Thank you so much. Yes, my brother, you can go ahead and introduce the chief executive.
Thank you very much, my lord, the PJ. I will also ride on the protocol already mentioned. Once again, on behalf of the industry, we really thank you for hosting us and what we have just been taken through. This morning, we have a number of CEOs and also all the heads of legal for all the 34 member institutions under the Bankers Association. I'll just introduce the CEOs who are here quickly. We have Michael Mugabe, who is also the chairman of UBA. We have the CEO of Baroda, seated right here. We have the CEO of Finca, seated here. We have the CEO of DFC Bank with us. We have the CEO of I&M Bank, seated with us. We have the CEO of NCBA, seated with us. We have the CEO of Guarantee Trust Bank here. We have the CEO of Pride Bank here. I don't know whether there are any other CEOs. Oh, we have the CEO of Bank of India here. We have the CEO of Cairo Bank here. My Lord, we have received the report very well, and we salute the team again, headed by the head of the commercial court. We have also taken the feedback that has been shared with us. As a Christian, I want to say that for us faith-based followers, we believe even without saying. But in this particular case, we have seen that 97 cases and 90 billion was unlocked. What better message could we have received from this? And that shows the sheer potential that is in ADR. Last week, we had a meeting, and perhaps the governor will speak to it. We have a monthly meeting of CEOs with the governor, and this matter was on the agenda. And the various dedicated officers, their absence and things like that, we discussed them. We are even thinking of one of the KPIs, because bank officers are measured on KPIs. And one of the things we're having discussion on is to measure recovery, legal, and risk staff and relationship managers by the number of disputes resolved through mediation instead of litigation. And so we are taking this seriously. It is a process. The level of appreciation, as you mentioned in your report, it is a journey that through the leadership of the governor, we commit to. It is a journey, and we will preach and practice and put it in black and white, because this is the only direction that will help us. We will be ambassadors of this. And so I'll keep my remarks brief. We are grateful. This is the direction we all embrace as industry. And once again, we are very grateful. Thank you very much.
Thank you so much, my brother Wilbrod, for that. It's nice to know that it's going to be one of the key, I think also for the judges, really, when we are making our performance reviews, we always want to know how many cases did you handle in mediation. I think that is also one of the things. I think that's the only way for us to make mediation the norm. And now it's my singular honor to, but before I invite him, I was first scared. One, all the CEOs are here, the chief executives are here. I hope our money is safe. You left, really. When you're here, who is looking after our money? Housing finance. And I also wanted to ask my brother, can I open an account in Bank of Uganda? A personal account?
No.
Okay. I invite you to please speak to us, my brother. Speak to us. Thank you.
Thank you. The Honorable Principal Judge. Allow me to stand on the protocol that was earlier observed. And I start by saying a very good morning to all of you. You see, an exit meeting can be many things. A formality to close a file, or a ceremony to mark an ending. I would like us to treat it as neither, later this morning as an audit. An honest accounting of what a fortnight of mediation has told us about commercial justice in Uganda, and a candid assessment of what it now asks of us. I want to start by thanking the Honorable Chief Justice and the Judicial Training Institute for convening us and for the partnership that has brought us to this point with real momentum. This gathering completes an arc that began at our colloquial in Chigo in April this year, continued at the Chief Justice Roundtable with the bank CEOs on 7th of May, and tested in practice at the settlement fortnight held at this commercial division from 18th to 29th of May. Each stage asked the same question, but in a different register: whether Uganda's commercial disputes will be resolved or merely adjudicated. Whether, to borrow the fortnight's own theme, we move from litigation to resolution. At Chigo, I did set out the scale of what is at stake in plain terms, and the number of the unresolved banking disputes, about 600 or so, at that time, holding an estimated Uganda shilling 7 trillion out of productive use. The Honorable Chief Justice, working from the Commercial Division's own docket, placed the value of pending cases at several trillions. 2 vantage points, 1 conclusion. Too much of Uganda's capital is not working. Is not financing the trader's next consignment of goods, the manufacturer's next production run, or the farmer's next season. It is waiting. Waiting on a mentioned date, a ruling, and an appeal. Capital, like blood, serves the body only in motion. Pulled in one place, like in commercial courts, however like that pull is, it does not do the economy no good at all. The fortnight gave us a reason to believe motion is possible. The statistics that were read out by the Honorable Justice and the head of the High Court Commercial Division is a testament to this. This is not a courtesy extended to litigants. It is a rule that they can rely on. And in matters of credit and capital, reliability is worth more than a sentiment. The Bank of Uganda came to this fortnight not only as a convener, but as a litigant. In our capacity as a liquidator of the Close Marketed Credit Bank Limited and the EFC Uganda Limited, we brought forward disputes that had, in some instances, outlasted the institutions themselves. We left with 3 consent judgments and a further suite of settlement proposals still under negotiations. Parties who once at the same table could design tailored repayment plans and negotiate interest concessions that no judgment, however sound, would have troubled itself to craft. This is what mediation does, and adjudication cannot. It feeds the outcome to a relationship that, in banking, usually has to continue. So, an exit meeting to be what its name. We must also be honest about what is still resisting us. Colleagues, you all agree that consent judgments still take longer to execute than the mediation that produced them, slowed by layers of internal approvals within our own institutions. Procedures still exist and insist in places of physical appearance where a signature or a video link would serve well. And some borrowers, frankly, still treat mediation as one more delay to be run out rather than the off-ramp from litigation that it is designed to be. None of this is a reason to read it from ADR. It is a reason to refine it. On our part at the Bank of Uganda, we will continue to ensure that the CEOs participate in this event will take whatever it takes to ensure that they do. To that end, I want to propose 4 priorities for the sessions ahead. First, if we're going to have future mediations, which I believe, I think the window should be extended so that we're not constrained by the arithmetic of the diaries. Second, streamline the consent judgment in chambers or electronically so that settlement reached in a mediation room does not lose momentum in a registry. Third, standardize tiered ADR clauses across financial contracts so that mediation becomes the contractual default, not a concession negotiated out of pressure. And last but not least, screen the cases for ADR suitability at the point of filing so that suitable matters are identified before court resources are spent on them and frivolous interlocutory applications are discouraged from the outset. These are just modest asks and deliberately so. Judicial independence and prudential regulation each depend on predictable rules, not on ad hoc goodwill. And the sixth judiciary strategic plan for 2025-2026 to 2029-30 rightly places ADR among the instruments for building that predictability, alongside the sector's own ambition to have the case backlog by the end of the decade. Institutions earn credibility the same way individuals do, by doing and consistently at that what they say they will do. We do not yet have grounds to declare victory. What we have is evidence that the direction is right, and colleagues on both sides of the partnerships are willing to keep working it. I thank the judiciary, the Judicial Training Institute, the Commercial Division Court, and every CEO bank and legal team that treated mediation as more than a formality of this fortnight. I look forward to our discussions this morning, which we have already had, and to the sessions that are going to follow next. I thank you all for your kind attention, and the good Lord bless you.
Thank you so much, my brother, and I think you have given us the, the way to go. And I was trying to write what you were about it and ask the judiciary about it, and ask the judiciary, we can only say thank you, and we are on board, and we shall give all the support that is needed for us to be able to take this forward. So thank you so much. We are now going to the next segment. We have shot by 8 minutes. May I invite back the PRO to take us to the next segment?
Thank you so much, my Lord Chair and Honorable Principal Judge. Let us give a hand clap to our session chair for taking us through very wonderfully. My Lord, we are going into a very brief ceremony for awards and recognitions. But allow me within just 1 minute, my Lord. The Executive Director, Bankers Association, has done me a very great job when it came to introducing the team that side. But also allow me to say one important thing to thank the Governor Bank of Uganda. My Lord, as the Executive Director was taking notes, I also took one very important note. And I think I heard him right. He said the judicial officers should now get interest-free loans.
Yes, I also had that. It was the first thing. It was the first one.
But I want to also tell him that we are very ready to get these interest-free loans, since all the chief executives are here. Of course, we have done a wonderful job, but we shall remain independent and impartial. Thank you so much. My Lord, allow me to introduce you. People may be wondering the one who will take that interest-free loan. My Lord Honorable Principal Judge, Late Justice Francis Abodo, just wave to the people. In the same vein, allow me to introduce my Lord Justice Mike Chivita, Chair Governing Council, and also chairperson, the awards and the awards committee, and Justice of the Supreme Court. My Lord, thank you for being here. Allow me also to introduce the focal judge, executive director, Digital Training Institute. Thank you so much for organizing us. My Lord, some people have met the head commercial division, but allow me to introduce Her Lordship Anna Mgenyi. Thank you so much. We also have the deputy head commercial division, Her Lordship Susan Apinyo. Oh, thank you for being here. We have His Lordship Isaac Bonnet Teko from the civil division. Thank you for coming. We have Her Lordship Patience Rubagumia, Judge of the Commercial Division. Thank you. We equally have from the from the Industrial Court, Chief Judge Linda Lydian Tumusimi. Thank you for coming. We also have His Lordship Anthony Wabwili Musana from the Industrial Court. My Lord, we have Mr. Justice Thomas Ochaya from the Commercial Division. Thank you for coming. We also have Dr. Inania Melody Mwatu from the Commercial Division. We have, my Lord, Mr. Alfred Hill from the IDLO. Thank you for being here. We also have beg your pardon, Honorable Justice Kahichi. She's here with us. These camera people decided to. We have mediators. We have Mr. Kwesiga James present. Thank you for being here. We also have Mr. Kenneth Barunji here with us. We have many in-house counsel. Let me request you please to stand up. Thank you people for coming. We also have Honorable Isala. She's here with us, a mediator, commercial division. Thank you so much for being here. My Lord, that then will facilitate us to know wonderful people who have come to join us. Members of senior management, please stand up. I've seen many of you and heads of department, judiciary. Okay, you're all here. Leader, representative of the Commissioner General URA, thank you so much. We have your worships, the registrars, magistrates, please stand up. Okay, thank you so much. We have all these members coming to witness this very wonderful occasion. My Lord, PJ, at this moment, allow me take us through the awards and recognitions. And I will invite the chairperson, Performance Management and Awards Committee, also Chair Governing Council, equally Judge of the Supreme Court, to take us through this very wonderful segment. And to assist, I will request you, my Lord Principal Judge, the Executive Director, the Head Commercial, Chief Registrar, the Governor Bank of Uganda, and the Executive Director Bankers Association. We shall go to the stage and we represent the rest as we give our people these recognitions. My Lord PJ, we shall be proceeding. Let us move to the stage with your permission, my Lord. request the registrar to come forward. Let us have this microphone.
Thank you very much, my Lord, the PJ, and my Lords, worships, the Governor, and the CEOs. Ladies and gentlemen, I'm going to read the citations. We have some few awards to give out. Citation for Award of Best Court Accredited Mediator. The success of the banking, loans, and credit sector settlement fortnight rested not on the bench alone, but on the quiet, disciplined work of the role of court accredited mediators, to whom disputing parties were referred for facilitation outside the courtroom. Among these scores of professionals, one man distinguished himself as a model of consistency, patience, and skill in the art of bringing adversarial parties to common ground. Over the course of the settlement fortnight that stretched into 60 days, this gentleman successfully facilitated the settlement of 27 cases referred to him by the Commercial Court Division, guiding banks, borrowers, and lenders through structured dialogue that resolved matters which might otherwise have taken years to conclude through trial. His command of process, his even-handedness with parties on both sides of the table, and his ability to keep sessions moving toward resolution rather than stalemate reflect the very qualities the judiciary's accreditation of mediators is designed to cultivate. Court-accredited mediators such as Mr. Kenneth Barunji are the hidden infrastructure of alternative dispute resolution. Without their referral caseload being competently and diligently handled outside the courtroom, no judge's docket could. Quickly moving on, forward of best court user. Success the success of any settlement fortnight is ultimately a function of the willingness of stakeholders, institutions to engage with candor, to make timely decisions, and to treat settlement as a genuine objective rather than a procedural formality. Among the banks that participated in this fortnight, one stood out for the quality and spirit of its engagement. That bank consistently availed its records and representatives with transparency, allowing judges and mediators to move quickly from clarification of facts to substantive negotiation. Where settlement required compromise, the bank's representatives came prepared with clear mandates and demonstrated a drive to resolve matters rather than defend positions, enabling a volume of settlements that reflected genuine cooperation rather than mere attendance. The spirit of transparency and constructive engagement is precisely what the judiciary seeks to encourage among its financial sector partners. And it is on this basis that Standard Chartered Bank is recognized as the best court user of the settlement fortnight. Ladies and gentlemen, please join me in appreciating Standard Chartered Bank as its representative come forward to receive the award for best court user of the banking, loans, and credit sector settlement fortnight. Representative from Standard Chartered, presented to Ms. Jacqueline Nagashon, presented to Ms. Jacqueline Nagasha in recognition of your timeless effort, remarkable negotiation skill, and commitment during the commercial court mediation settlement fortnight. All right, we have our final awards for this morning. Citation for award of Best Judge Mediator. During the settlement fortnight that stretched from the initial 14 into 60 days, the Commercial Court Division carried a combined docket of 6,751 pending cases distributed among 8 judges of the division, an average sitting caseload of approximately 844 cases per judge. The settlement fortnight was convened to confront this docket not merely by volume, but by value, placing emphasis on resolving disputes of significant financial consequence to litigants, banks, and the credit market as a whole. The CJ has always emphasized that judicial officers should offer leadership during mediation, and the judge cited has provided leadership in completing the highest number of cases during the banking loans and credit cluster settlement fortnight, even in the value of subject matter. Amidst the odds of her heavy workload of 900 plus cases, Justice Patience Rubagumia completed she completed 41 cases through mediation, successfully settling 20 big lapping hardest because we got big lapping hardest because we got just patience from Uganda Revenue Authority.
Thank you so much. I request that we receive up 6. I request that we receive up 6. Let me request that we give a hand of applause to the Chair Governing Council for performing wonderful assignment. And my Lord, thank you also as Chairperson, Performance Management and Awards Committee for really proving that best performers will always be rewarded. Thank you so much. With that, allow me invite you, my Lord PJ, to give your remarks. Thank you so much.
Thank you, PRO, and congratulations to the winners, but also the ones who participated. I think if everyone else didn't participate, you'd not really be the winner because there would be no winner anyway. Yes. So thank you so much and congratulations. I want to say again this morning that I am really, really excited to see the number of people who have turned up this morning, and you were here in time before 7:30. So I want to commend you for that and once again welcome you to the judiciary. It's my singular honor really to join you this morning as we reflected on the recently concluded mediation settlement fortnight, which was a huge success, and we should clap for ourselves. Yes. I wish in a special way to commend the commercial division for once again demonstrating that mediation is not merely an alternative to litigation, but it is a powerful tool for delivering timely, cost-effective, and business-friendly justice. Every matter that was settled represents more than a closed file. It signifies relationships that have been preserved, commercial confidence that has been strengthened, in a manner that allows parties to move forward. We say that disputes can put like a full stop or a comma into our lives, but once it is settled, people can now move on. I want to extend my sincere appreciation to the Governor Bank of Uganda in absentia for mobilizing the bank executives who have been here. My brother Wilbrod, thank you so much. And it gives us confidence that you are really in it. And of course, the judges, our registrars, headed by the chief registrar herself. Yes, the registry is very important in this, so we want to thank you for that. of course, the wonderful mediators, the advocates, the court staff, and most importantly, I think the litigants who embrace dialogue over prolonged litigation. Your collective commitment made this exercise a success. We would not be celebrating this morning. As we reviewed the outcomes today, we are celebrating the achievements, but we have also candidly taken note of the lessons learned, and we should also ask ourselves what worked well, what challenges remain, and how we can institutionalize best practices so that the spirit of mediation extends beyond the designated settlement sessions. I think we have all agreed to that. Everyone spoke to that. The head of the commercial division spoke to that. My brother Tingu Ego spoke to that. So it is the way to go. We want to make it a everyday case management tool as a judiciary. As a judiciary, our strategic direction is really to promote appropriate dispute resolution. That is our strategic direction. And we reduce case backlog and, of course, improve public confidence in our courts. If there's anything that the judiciary as an institution should really, really value, is confidence in our courts. That's the number one thing. Once people lose confidence in the courts, then there's a problem. Then why do we even exist? The commercial division continues to lead by example, and I encourage you to keep innovating and sharing these successes across other divisions and circuits. And finally, my Lord Patience, I am basking in your excitement. Yes, that's why I told you wear blue today, so that I can also associate. You know that we are one in this. Congratulations, we are so proud of you. Yes. Thank you once again. I say all this for God and my country, and I now want to officially declare this exit meeting open, close. Thank you.
Thank you so much, my Lord Principal Judge. Let us all rise for the national anthems. Thank you so much. And my Lord, with your permission, we shall have only 4 photos. And I would like to request our media team to prepare our setup so that our guests can now proceed to their.
James, where is it? Here?
We shall. I think we shall ask that we sit. Yes. So the first photo, I will request the judges to join you. Can we adjust the high table? Can we adjust the table and the chairs to accommodate? The high table remains constant. The high table remains constant. So, my lords, thank you. My Lord Anthony, if you could extend a little to balance it. My Lord Ochai, I think you could have been the other side with my Lord Rubagumya. Kahigi, patience will be lonely. Thank you. The next picture, we shall have the CEOs and managing directors. The CEOs and managing directors. Now request the Uganda Revenue Authority and IDLO to.
All right. Katutugenze, we are going down for Elias Lukwago. Here we are done. Let's meet up.